I think we are complete now. Mr. Kafia is here.
You're online.
So it's 12. Are we good to go?
You're live.
It's 12 noon. It is 12 noon.
Okay. I believe we are live right now. Okay. Good afternoon, everyone. Good afternoon, ladies and gentlemen. On behalf of the Corporate and In-House Counsel Committee of the Chartered Institute of Arbitrators, I warmly welcome you all to today's webinar. As you all know, the title of this webinar is The Seat and Venue Equation, Considerations that Impact Your Arbitration. Thank you for joining us, and we are delighted to have participants from Nigeria, Ghana, and across several other African countries. My name is Michael Luka. I am a fellow of the Chartered Institute of Arbitrators, and I'll be serving as the coordinator for this session. So in today's session, we are going to be exploring one of the most important choices that parties can make in arbitration, which is the seat and the venue. And our expert panel will help us to unpack how seat and venue can influence the entire arbitration process and enforceability, and strategic considerations that matter at the drafting stage. Just a few housekeeping points. This session will run for approximately 90 minutes, and it is being recorded. Participants will be muted all through the webinar. Please use the chat box or the Q&A tab to drop your questions at any time. We'll take as many questions as the time will permit us during the Q&A segment. And then please keep your messages respectful and relevant to ensure a smooth and focused discussion. For the speakers, we are glad to have three esteemed speakers who will be speaking to us, and I'll be introducing them in no particular order. We have Mr. Godson Ugochukwu, a senior advocate of Nigeria and fellow of the Institute. He's the co-founder of Fortress Solicitors and has over 22 years experience in international arbitration, litigation, and alternative dispute resolution. He sits on the boards of various companies, including the board of Guinea Insurance PLC. Then we also have Ms. Henrietta Newton-Martin, an award-winning legal specialist and author with over 18 years of expertise in cross-border commercial law, strategic governance, and dispute resolution. She's based in the Middle East and advises multinational corporations across sectors, including aviation, FCMG, oil and gas, and technology. Last but definitely not the least, we have Mr. Michael Akafia. He's the Vice President External Affairs at Goldfields Ghana Limited and the President of the Ghana Chamber of Mines. He holds an LLM in International Dispute Resolution from the Queen Mary University of London and is an investment advisor, arbitrator, and legal 500 power list honoree. Our moderator for this webinar is Dr. Miriam Shehu Mohammed. She's a fellow of the Institute. She's a company secretary and legal advisor of Mafab Communications Limited, a seasoned legal practitioner with over 2 decades of experience spanning prosecution, energy, telecoms, and infrastructure. She holds a PhD in law from the Ahmadu Bello University and is a Mandela Washington Fellow, of course, a fellow of the Institute, and a respected governance and compliance expert. She'll be steering the conversation today. And ladies and gentlemen, at this point, I'll be handing over to Dr. Miriam Mohammed, who will guide us through the rest of the session. Thank you very much. Dr. Miriam, over to you, please. Hello? Yes, we can hear you.
Hello.
Yeah?
How many people do you pay for the
1,000, 1,000, 1,000.
Oh, 1,004, right?
Please,
And YouTube is
I
not
will
working.
implore everyone who is not speaking to mute their mics, please. So, Dr. Mohammed, the floor is open.
Hello. Oh, hello. Purple.
Dr. Mohammed, there appears to be an issue with your audio. We can't hear you.
Michael.
Can you hear me? I had to
Oh,
leave
please
and
continue.
return.
We
Okay.
can hear you now.
Okay.
Okay. So welcome to this webinar. We're discussing a very important issue that ordinarily it's very important for us to understand the difference between the seat and the venue and why it is important for us to be strategic in selecting our seat. So first of all, I'll take the question, I'll ask our learned Silk, first of all, as the foundation, what are the major considerations for choosing a physical venue separate from the seat, especially in light of the rise in virtual hearings? That's one part of the question. The second part of the question is, how does the choice of the seat practically affect the conduct and trajectory of arbitral proceedings beyond just theory? Leonard Silk, you have the floor for 5 minutes to answer this question for us. Thank you.
Thank you, Dr. Mohammed. And again, thank you to the Chartered Institute of Arbitrators, my beloved institute, for taking the risk to invite me in this. I don't know you guys to be gamblers, so I hope that the bet you've placed on me, I hope it pays off. But I'm definitely a happy camper here. My name is Godson. If we can drop all the honorifics and just say, put the question to Godson, I'll be happy to take it. Doc, you did say the question is twofold. So I will urge you to follow me closely. If I miss any parts, I will be depending on you to remind me. Now, let me see if I can do justice to this and make short work of it within the 5 minutes I've been given. The importance of the seat, the choice of the seat, that's the first limb, right?
Yes.
So I think that I would not be hyperbolic if I were to say that possibly the most important decision, or maybe one of the most important decisions you can make in drafting an arbitration agreement, is the choice of the seat. It is extremely important. And any practitioner in this space who is drafting or reviewing a contract with an arbitration clause, who decides to be cavalier about the choice of the seat, is taking a very big risk going forward. If there's anything in arbitration that speaks to your foresight, it is actually in this narrow compass of the decision as to the choice of the seat. Now, enough emphasis on that. Suffice it to say that the primacy given to that choice, the importance of that choice, why it is underscored, is because the law of the seat of arbitration is actually the law of the arbitration itself. That's why it's called the lex arbitri. So the court of the seat provide or have primary supervisory role over the entire arbitral proceedings. if you want to challenge the appointment of an arbitrator, if you want to obtain interim measures, if you want to, whatever it is that you want to do to in aid of the facilitation of the process, your recourse would be to the court of the seat. And I do believe that having put this out there, it's beginning to be clear to, if it wasn't clear already to anybody, that the choice of that seat is extremely pivotal. Look, it's no different from the choice of a spouse. Okay, you take what you get: conduct, complexion, composure, anything. Everything comes together. So if you're just choosing the seat, you are choosing not just the court but the legal system itself. So it's extremely important that you pay attention to that, because it is not just its benefit or its impact is not just limited to the proceeding itself. It also goes as far as what happens post-award. If you want to challenge the award, if you want to set it aside, your primary recourse will be to the choice of the court of the seat. So that's, I think that should be that, given the limited time we have. Now, the
Thank
second,
you. Okay.
Yes, Doc.
Okay, I was going to ask you about the venue. Juxtapose it with the venue. Yes.
Yes. The second limb of the question is as to venue. Now, venue is purely if the seat is the life source of the arbitral proceedings or the graveyard of the award. Consider the venue as just a matter of logistics. It's a question of logistical convenience or cost. So the venue itself is basically the place where the arbitration takes place. And in these days, you know, in 2020, the COVID-19 onboarded the entire world onto the virtual planet, where there's no getting off. We are here now, including what we're doing now. What we're doing now could very well be an arbitration proceeding. The question now becomes, where is the seat of that arbitration? And where is the venue? The venue, generally speaking, could be Zoho, Zoom, Link, whatever. The venue could be, but the seat is where the parties at the point of drafting the contract agreed to be the seat. So we are all, as I speak to you, I'm in Georgia, I'm in Atlanta. People are scattered in different parts of the world. That is just the venue. That's where if this were an arbitration proceeding is holding online. But where is the seat? The seat could very well be Singapore, it could be London, it could be The Hague, it could be Switzerland, Geneva, it could be anywhere. That is the law. Despite where we are, the fact that I'm here and everybody is in different parts of the world, the fact is that the law that will supervise these proceedings will still be the law, say, of The Hague, of Netherlands or Switzerland or UK law or wherever we choose to be. So hypothetically, we are here, but in actual fact, where the rubber meets the road in terms of the law, it will be the law of, say, the law of Nigeria, if you like, if that's the seat.
Thank you.
Thank you, ma'am.
Thank you, Leonard Silk. Thank you. Thank you. This has given us the foundation we need, because even a layman would understand the difference between the venue and the seat. And especially since we have a lot of virtual hearings now, so your seat is very critical to the choices you make, because you come back to do your enforcement and whatnot. And even if you want to challenge the award, it is the law of the seat that will support what you're trying to do. Thank you very much, Leonard Silk. Sorry, I'm still calling you Leonard Silk. I pardon me. So our next question is to, and thank you for keeping to time. Our next question is to Ms. Henrietta Newton-Martin. You've advised multinational corporations across diverse sectors in the Middle East. How do these companies typically approach the selection of a seat and venue in arbitration clauses? What strategic or commercial factors dominate their decision making? This question is for you, Ms. Henrietta. Am I still connected? Am I audible?
Yes, I'm so sorry.
You are.
Okay.
Muting my mic. Thank you, Dr. Miriam, at the outset. And greetings once again to all the panelists, and apart from the panelists, all the people, the participants rather. Regarding the venue and seat, the primary factor that normally, just not in the Middle East, I think the lawyers world over would agree with me, would be about crafting. Note the word that I have used. I've used not drafting, but I used the word crafting. Crafting the arbitration clause. Arbitration clause is mostly pushed aside by the legal team as a boilerplate clause, right? But then what happens is we have this a particular clause in mind. We just draft the clause, or we just put it there. But then the problem arises when there is a dispute. So I would say world over, in arbitration clause, while crafting it or even drafting it, the problem arises in conflation between the venue as well as the seat, where people interchangeably use the terms venue and the seat, right? Mm-hmm. So while advising MNCs and even having experienced so many years, there are two factors that normally any MNC world over would consider. One is a legal predictability of it, and on the other hand is the commercial pragmatism, right? One is legal predictability, how the case would evolve, should there be a case or should there be a dispute which snowballs into a litigation, how it would evolve. That is the art of a lawyer, where he foresees, he predicts. So legal predictability at the time of crafting the arbitration clause or whatever jurisdiction clause, the governing law clause. And on the other hand, commercial pragmatism. In my experience, the top management or even the executive stock level, they normally go for convenience and something which is cost effective. And that is what has happened in one of the cases that we handled recently, where the party was from Turkey and of course the other party is from UAE, and they were negotiating a contract. And then they said that, no, we want English law. And the executive said, we want the venue as Dubai. So the legal team, just to talk about it in a light note, we said that let's harmonize both, where one of them is asking for sunshine, that is Dubai, and the legal team is, concentrating on Shakespeare, that is the English law. So we gave them both. We went by the English law, and then we said the venue. So when I'm talking about the venue here is the physicality of the physicality of the matter, where the dispute can be conducted, or the dispute can be whatever would be handled at a particular case or court. So this is what is the difference between venue and the seat. Seat also points out to the governing law. The seat of arbitration also points out to the governing law, right? Whereas the venue is just the physical place where the thing would have been held. Like, for example, Mr. Godson said that it could be even a meeting room like this. It could be, by Zoho or Teams or Zoom. So it doesn't matter. So that is, you could call it a venue, okay? But I would also put it this way, that the seat can also be called as the legal home. The legal home where the procedural law applies, where the local courts will intervene, depending upon how, what is the matter, it depends upon what is the matter, and whether at all the arbitration jurisprudence is, built to that extent. It depends upon country to country, right? So, for example, Dubai is the most favorite hub, where we have DIAC. Then we have LIAC, that is London International Arbitration Center. We have SIAC, Singapore. So these are some of the hubs where lawyers normally prefer because of also the infrastructure that they have. So I think I've answered your question.
Yes, you have excellently. Thank you. So a lot of things to unpack from what we just heard from her. So notwithstanding the fact that we want to save cost, notwithstanding the fact that it may be convenient to be in a particular place because parties are close to that physical venue, the seat is what determines your enforceability. For example, the seat is the law, and that's what is most important when it comes to enforcement. Thank you very much for that. And thank you for keeping to time. I'll always thank you for keeping to our 5 minutes. Mr. Michael Edem, thank you. Mr. Michael Edem, the next question is yours. As someone who has worked at the highest levels of corporate governance, legal services, and compliance in Ghana's extractive sector, what are the key factors an in-house counsel should consider when selecting the seat for a commercial contract? Part of the questions have been answered by the first two speakers, but we want you to speak to us from the perspective of your Ghanaian setting. Mr. Michael, are you with us? Mr. Michael? Okay, maybe he's having a technical glitch like I did earlier. So maybe I'll come back to Miss Henrietta, because
Yes.
there's a follow-up. Is Mr. Michael here? Okay, Miss Henrietta.
Yes.
You just talked extensively about what typically guides your selection of a seat. And there's simple considerations like convenience, for example, saving costs and all of that. Now tell us, given your insight into contract law and strategic governance, what are the top pitfalls and misconceptions that we have? What are the top pitfalls that drafters should avoid when specifying the seat and the venue in arbitration clauses? What are the easy problems you can get into when it comes to drafting? And then what are the misconceptions around the seat that you've come across?
Thank you so much, Dr. Miriam, once again. So I would reiterate what I spoke about earlier about the misconception part of it. So I think the answer lies in conflation, where lawyers sometimes interchangeably use the term venue and seat, where sometimes while drafting the clause, they fail to craft the clause. So that is one of the pitfalls that I've always observed in various contracts, even if the contracts have come over from some other country, from some other company. So I would always advise on drafting a well-drafted clause. Why I'm thumping upon that aspect is that is the first thing that any lawyer or any legal department would go into while initiating any legal proceeding. We would first see, where should I file this litigation, right? So that is the reason contracts, that the drafting and crafting of the clause plays a very important role. It seems like a cliche. It seems something like, well, I know about it, but it is something in what we know that we falter. So this has been my experience, really. Like, for example, the most recent case, it is an Indian case, of course, in 2024, which took place as Arif Azim versus Micromax. In this particular case, a simple sentence in the arbitration clause created a huge ruckus and problem in solving the matter and costed the companies even millions of dollars in resolving the issue. And the sentence was, the venue of arbitration shall be Dubai. Now here, in this matter, Arif Azim is a company that is in Afghanistan, and Micromax has its company, the holding company in India, and the subsidiary company in Dubai. So the arbitration clause said that the venue will be in Dubai. Arif Azim never agreed to that. He contested that, and they said that no, they initiated proceeding in India. So these people here, that is Micromax, vehemently protested that, and they said, no, we'll have to hold the proceedings in Dubai at the DIAC. So you see, now the Supreme Court of India was like, they were confused, they were confounded. So as you know, India also follows the English law pattern and the common law pattern. They rely heavily on judicial proceedings. So they went back to study all the judicial proceedings, and they, long story short, keeping myself, within the time limit, they went through 3 important cases, and then they said that, they concluded finally, well, the question arises, which is the venue? Dubai. So when they said venue as Dubai, is there anything else that we can find in the clause? So the clause said Dubai laws would apply. The word seat is not used, but they said that Dubai laws would apply. So check.
That's the
venue is Dubai. The laws applicable, check, is Dubai. So that means you can conclude the venue and the seat is Dubai. So Arif Azim's petition was dismissed, and then they brought back the case to Dubai. Yeah. So this is Arif Azim versus Micromax 2024. Just last year, this case was decided by the Supreme Court of India. So this is something. So now you see how drafting this contractual clause is so important. Carefully crafting it. So I would say that clarity is the king. That would save millions of dollars or dirhams or rupees, whatever currency it is. So you would save a lot.
Okay. Thank you. Thank you. Someone needs to mute. Someone needs to mute himself or herself. Admin, we have an echo. Can you help us mute the interference? So thank you so much, Ms. Henrietta. This case has shed light on the kind of confusion that can arise from not properly crafting, not drafting, as she said, crafting your arbitration clause. A sentence can cause problems, delays, everything about arbitration. The advantages of arbitration is that you save time, you save energy, you save resources, because you choose your arbitrator, you choose your venue, you choose how you want to conduct, you choose the law. But the failure of the drafters or crafters of the arbitration clause can render that possibility null and void. So it's very important for us to be able to, if we don't know, we can learn from those who know. And there are many templates. There are many templates, excellent templates that you can learn from. Learning, we continuously learn, and that's what her contribution is telling us. Mr. Michael Edem Akafia, are you with us? Can we ask a question now? Yes, Mr. Michael. So,
you hear me now?
Yes, I can hear you now. Earlier, I think you had a technical glitch. We couldn't hear you. Please, can you share with us your thoughts on how the choice of seat can impact the tribunal's power to grant interim measures, particularly interim measures, because we've talked about the impact, of course, of the seat, but that's one part of the question. And then we would like to hear an example that you've had as general counsel where the chosen seat or venue positively or negatively influenced the resolution of the dispute. In other words, have you witnessed a dispute where a strategically chosen seat or venue became a critical turning point, a crucial turning point for your arbitration?
Thank you so much. And I think I'll just start from the issue of the interim measures. And as you would know, you from an in-house perspective, you're always looking at arbitration cases from end to end. And we know that interim measures usually relate to those things that the court or the arbitral tribunal may make an order in respect of before the final award is given. And so typically it is meant to address certain issues, preservation orders to try and preserve certain, and then also sometimes freezing assets with regards to certain assets that may be dissipated. It may be with regards to even so there are many considerations that come to mind when it comes to that. I mean, when it comes to the issue of the seat, to the extent that the other speakers have pointed out, Godwin and Harriet have pointed out that is key in determining the governing law of the arbitration, or the law that determines what supervisory powers or not a court may exercise. You will then have to exercise a choice of a seat with that in mind. If you choose a seat that, first of all, has a law that is modeled on the UNSUTRA model, it's likely that it's more arbitration friendly. And so you would find that that kind of law will vest more powers in the arbitral tribunal in determining your interim measures. Now, if it were to be a matter for the courts, you should also look to choose a seat that would have courts that are known to have a more positive attitude towards arbitration generally, and will be supportive, will provide a supportive framework for the arbitration to carry out. The reason why this is particularly critical is that we know that certain interim orders can effectively dispose of the case. We know that a person can ask for an interim order even before the commencement of arbitration. So that may have the effect of even stalling the whole arbitration process if the court were to make a decision that negatively impacted on the progress of the arbitration. So that is one of the things to bear in mind. And you know that even when it comes to even the constitution of the arbitral tribunal, the court may take a view and then make decisions that may affect that. And in Ghana, we have a series of cases that really relate to a arbitrability, because under Ghana's Alternative Dispute Resolution Act, constitutional matters are deemed not to be arbitrable. So that to the extent that there's even a commercial contract between a party and, say, the government of Ghana, one of the requirements of Ghana's constitution is that certain contracts, international contracts, must be approved by Parliament. Now, in a number of cases that have come to pass, people have raised the issue of arbitrability because the Alternative Dispute Resolution Act is quite clear that constitutional matters are not arbitrable. So that if a court in Ghana were seized, if Ghana was a seat of arbitration, a court in Ghana was seized of that matter, and it turns out that the agreement in question between the parties, and involving government as well, has not received parliamentary approval, it is likely that this will be determined to be the arbitration agreement. As we know, under the principle of separability, the arbitration agreement itself may be distinguishable from the underlying agreement. But because of the principle of arbitrability and the provisions of the Alternative Dispute Resolution Act, Ghanaian courts, especially the Supreme Court, has held that once you don't meet that requirement, your not just the arbitration agreement itself will be void for that reason. And so and in fact, some of the practical effects of this is that in some cases, the parties, including even the government of Ghana, has chosen a foreign seat, another seat other than Ghana, as a seat of arbitration. And that has had the effect of bringing a conflict between what an arbitral tribunal will hold. And in fact, in one of such cases involving Malaysia Telecom, the government of Ghana lost the case by virtue of choosing a seat other than Ghana as arbitration, because once the arbitral tribunal applied the law of the seat, which in this case was Netherlands, the effect of it was that even though Ghana raised an objection that was valid, that would otherwise have been valid regarding one of the arbitrators, because the arbitrator had involved himself in a conflict position. Once Dutch law was applied, the effect of it was that, unfortunately, Ghana was determined not to have the capacity to void that particular agreement. And so Ghana lost that case on that account. So these are some of the, and then as an in-house counsel, because you know that, you know, these things have the thing about the seat you choose, to the extent that that may vest the arbitral tribunal with vast powers, because it is that which will define the kinds of powers that the arbitral tribunal have regarding interim measures, you know. So that's one of the things to look at. And then in terms of your other question about the example, positive and negative experiences we've had regarding arbitration, I think I'll cite these similar cases. One of them where Ghana, and maybe I'll start with the positive, where even though Ghana chose England as a seat of arbitration, when the English court was applying the law, it concluded that by virtue of the provisions of English law, Ghanaian law should be applied. So ultimately, Ghana got a favorable award in that regard, ultimately because it chose a seat that was favorable to it. Now, if you contrast that with the Telecom Malaysia case, where Ghana chose another jurisdiction, the outcome was negative for Ghana precisely because Ghana chose a seat. And in fact, what was clear also to Ghana was that even the decision of the tribunal ultimately was not consistent even with the position that had been taken regarding the person that Ghana was objecting to. That person himself had acted in counsel and has taken a position similar to what Ghana had taken. But because the law was favorable to that other side, the other party other than Ghana, the other party, Ghana lost that case in that regard. So it shows how this can become a turning point, or the key turning point in deciding whether you get a favorable award or not. Now, I mean, we're talking about mining jurisdictions, and mining extractive sector, they are quite global in nature. So what that means is that it has cross-border implications. And other speakers have touched on the issue of enforceability. So one of the considerations in selecting a seat is to determine, for instance, whether that party where you seek to enforce the arbitration is in a country that is a signatory to the United Nations Convention on Recognition and Enforcement of Awards. So otherwise, you'll be incapacitated and you'll not be able to enforce the award subsequently, you know. And so those are some of the considerations to take into account. Regarding the interim measures, if I take you back a bit, if it's in respect, it's a freezing order, and in fact, it's a global company that has footprints in multiple jurisdictions, the decision as to which seat to choose is critical, because you may end up with a seat where the company that you're going up against has no assets that you can go you can go against in terms of enforcement and so on and so forth. So those are some of the things to bear in mind when you are choosing the thing. I mean, just to point out that because the choice of the seat has far-reaching implications regarding how the outcome, you as in-house counsel, you should start with the end game first in mind, but then also think of this from end to end in terms of the implications from interim measures, you know, all the way to when you can enforce, whether or not you can enforce any award that you get subsequently. Thank you so much. Apologies for all the challenges.
It was well worth the wait to hear you speak, Mr. Michael. We've learned so much from your experience as in-house counsel, and the experience of Ghana, positive and negative, of their choices of seat. And most of us, this is an in-house counsel committee, and most of us are in-house counsel that are venturing into arbitration. And there's a lot to learn from people who have been in the practice and have seen the impact of what they do, which brings us back to the issue of crafting an excellent arbitration agreement, clause or agreement in your contracts. Thank you, Mr. Michael. Participants, you are free to post your questions in the chat group, because we're going to take questions in about 20 minutes time. So post your questions so that when it comes to the question and answer, we'll be able to answer your questions. Now back to Leonard Silk. How do institutional rules, example ICC, LCIA, UNCITRAL, interact with parties' choice of a seat and venue? How do these institutional rules impact or interact with the party's choice of a seat and venue? Mr. Godson, over to you.
Thank you very much. Interesting points overall by all the speakers, quite engaging. Listening to you all, I wished I were in the audience because I have questions I could have put to you, Michael. Interesting points you raised about the impacts of certain decisions with regarding Ghana. Henrietta, sound solid points in regard to the conflation of seat and venue. I actually had a follow-up on Henrietta's point, but then looking at this, the question I'm going to be selfish and try to make short work of it so I can maybe spare a few words on the points that you guys had raised before. So generally, suffice it to say that all the rules of that you've mentioned, the SCIA, the ICC, the I'm sorry, school run comes to say bye-bye today. My apologies. All the rules you've mentioned, primarily as a golden rule, each of these institutions respect and defer to the choice that the parties make in regard to the seat. It's a golden rule, it's inviolate, it's inflexible, it applies. If you are drafting or as in-house counsel reviewing any arbitration agreement, do not sweat it. Look for the seat. Be sure that the seat is made clear and imputed, because whether it is an institution, in any of these institutional arbitrations, all of those institutions, and I know that this cuts across, is an equal opportunity employer. It cuts across from London to Singapore to The Hague to Dayak, where Henrietta is, everywhere. Institutions and their rules respect, down to our own AMA. They respect and treat the choice of venue, choice of seat by parties as sacrosanct. Now, where you begin to find the nuances are where the perennial problem, where conflation of seat and venue in poorly drafted, I might add, arbitration agreements, where people just tend to take it for granted that when we say the arbitration shall be held, the venue shall be in Lagos or in Dubai or wherever, we meant seat. Different rules now begin to try to provide how to deal with that. And that is where you find the intersection, the intercourse, and the interaction that you're looking at. So, for example, let me start from home. Our own AMA provide, that's the Arbitration and Mediation Act. In simple fact, says in the absence of that of a provision, express provision for seat, venue would equal seat. So if you are the law of the arbitration is the AMA and the rules made thereunder, and you say the arbitration, for example, shall be held in Lagos or in London or in Singapore, you have just referred to venue and you say no more than that, then the AMA would say what you mean by that is that the law of the venue is the law of this, is the seat, is the law of the seat. And so we will sweat it no more. Unless, of course, according to the AMA, unless you specify clearly that you meant for the venue to be venue only, then the question becomes, you have to provide the seat. If you do not provide the seat, then the arbitral tribunal will be at large, at liberty the question will be at large to the arbitral tribunal. The tribunal will be at liberty to determine what the seat would be. Of course, how did the arbitral tribunal slices and dices that would be up to the arbitrators. Usually, all those questions as to proximity, the most impacted venue, all of those things would come into consideration. That is where you now begin to elevate the consideration that you make in choosing venue become what will be elevated in determining the seat. The LCIA takes the default position that the seat of the arbitration is London. So whereas the AMA is saying venue equals seat, the SCIA wakes up in the morning, stretches itself and says, the seat today is London, and so shall it be every day, unless you state otherwise. So if you are looking to arbitrate under the LCIA rules, you had better make clear whether what the seat is. So if you say the venue of the arbitration shall be Lagos, and you're operating under the LCIA rules, the seat of the arbitration is London, and that means the law of the seat, UK law, will apply. I think the ICC generally gives the tribunal the jurisdiction to determine what the seat would be in the absence of an express provision. So yes, that is how these things interact. Let me close out by saying that the more we discuss this particular topic, I am hoping that it is becoming clearer and clearer that this issue of the seat should engage proper due diligence by drafters and people sitting in-house. When we external solicitors send in our drafts to you for review, you should take a red marker and circumscribe that question. Even where we have provided that, I would suggest most respectfully that your question back to us should be, please explain what led to this choice of seat. We need to advise you ahead of time as to what led to it. Let me also clarify a point that Michael, when he was speaking, raised. Lest anybody thinks, because when he analyzed these very interesting cases, maybe some people will think that, will get the impression that you begin to choose the seat when the problem arises. So for example, when he says Ghana chose this place, you know, they not initiate, if you're wet around the ears as yet, you will think that he's suggesting that, oh, when the dispute arises, then you choose it. No, you must bear in mind that as practitioners of law, for instance, we are vested with the power of clairvoyance, or you are expected to have it. So you must, when you are drafting, at the point of drafting, everybody is we are all kissing and falling on each other's neck. We're all very happy. There's no problem at that point. You, the lawyer, must take the negative perspective. What about when the problem arises? Because all of those decisions were made at a point where parties were still extremely in love with each other. Then problem happens. So the lawyer is the person who is the party pooper. You are supposed to be the one who takes a negative view of things, and then you have to, in drafting and in reviewing, take the view that this problem, these people that are loving each other now, they will have a problem. And if they have a problem, how do you solve it? And that is where the choice of the seat. You must do your proper diligence. You must raise the table, look under it, shake out everything, find out how it absolutely serves the purpose, at the very least, of the person paying you in choosing the seat. And with this few words, I will yield. Thank you.
Thank you, Mr. Godson. So it's not the thrill of falling in love, right? It's the post-divorce consequence that we're looking at the situation. Okay, thank you very much for that. Okay, so back to Ms. Henrietta. What role do you think neutrality? So this is a follow-up on the issue of Ghana, you know, and the case that you mentioned about Dubai. What role do you think neutrality, reputation, and local infrastructure play in making a jurisdiction attractive as a seat? I'm sure all the other speakers have touched on it a little bit, but we're bringing out this question so that you advise us regarding what are those factors that would influence you to choose a particular seat. The floor is yours, Ms.
Marian, once again. Thank you really for the question. Talking about neutrality, this has a very, I would say, a very general answer, where every lawyer across the globe would agree. Why do we choose a neutral jurisdiction? Is because the parties do not have the comfort of home laws and home courts supporting them. So that is the basic, and there is obviously there is no question of influence as well. So that is the reason to ensure transparency, efficiency, and fairness of trial, or fairness in arbitration. That's the reason we go in for a neutral jurisdiction clause, right? For example, we are here sitting in Dubai, but we might say, I do not want to apply Dubai laws or UAE laws to be precise. mostly in my experience, I normally choose English laws. So I would say I choose English laws for neutrality of the jurisdiction and neutrality part of it. I choose English law, but the venue would be, now that means when I'm talking about neutrality, somewhere it points out to the seat, right? So the seat of arbitration, that means it points out to the laws that are applicable, the procedural laws that are applicable, and the legal decisiveness, the legal harm. So I'm choosing English laws, the venue as DIAC, because the parties will not be, will not be able to, really influence the matter. And the arbitrators, again, I have my choice of arbitrators as well. So again, that is something that fortifies the factor of neutrality. What happens here is you gain transparency, fairness, as well as it ensures justice in a way, right? So that is neutrality part of it. Talking about reputation again. Now, reputation, of course, it instills confidence in a neutral investigator, because now that thing gains reputation, where the person who's investigating the matter or who's also arbitrating the matter, so that situation, it gains reputation. Now, for example, in DIAC, we had a particular case where we chose an arbitrator from some other country. Maybe hadn't traveled all the way here. He was from London. We hadn't traveled all the way here. We chose, he was on the board, of course. So we hadn't traveled. So that ensured neutrality. He applied English laws. And then again, he had a reputation. There was a particular reputation. He built that reputation. The situation was different. So that is about reputation. Next is the third thing you asked me about was neutrality. The third thing you asked me about, if you could remind me.
Local infrastructure. Local infrastructure.
It does play a very important role, in the sense, like, for example, I remember while I was answering the first question, I spoke about why DIAC and SIAC is the most preferred hub. It is because of the infrastructure that they have. The hearing rooms have these automated translation systems. You see, so infrastructure in arbitration certainly plays a very important role, because you have parties from all over the world who might have even virtual hearings. So there is this translation mechanism which is there. So that helps us. So infrastructure does play a very important role. So neutrality, infrastructure, and reputation. So apart from that is, yeah, I think I have answered your question.
Yes, and in addition, you see, the network, for example, I've been kicked out of this meeting once or twice. So the even the strength of your network, where you are, plays a role in your proceedings.
Perfect.
Thank you very much. Yes. So we have less than 10 minutes to go, and I have two questions for both Mr. Godson and Mr. Michael. So we'll share that 7 minutes between the two of you. Mr. Godson, what is the implication of the seat of arbitration with respect to enforcement of foreign arbitral awards in Nigeria, particularly in the light of well-known conflicting Court of Appeal judgments? I know this is something that is a discussion for a whole day, but we're packing it into a few minutes. Just give us your comments. You know, we talked about Limak and Sahelian, and there are a number of other cases. Just shed light on it so that... Is Mr. Godson audible to you? I can't hear him.
Sorry, my apologies. I had muted myself.
Okay.
I was joking to one of my colleagues in the office yesterday, the day we had a speaker's prep, that when you put this question, you just left it as in light of the two recent decisions. And I said to myself that was a curveball, almost trying to know if this silk gown, I should wear it or return it. You know, because
no,
I hid on that. I hid on that the fact that God forbid that a man should know all the law. Interestingly, fortunately for me, I had happened to it happened to be someone that has the two cases fully engaged me before you mentioned that. So gave me an opportunity to sound like I know something where I didn't know much. Anyway, so Limac and Sahelian, and then Champion Breweries and Brauerei Beck would be right now the topic of the day. The interesting thing is that Limac was decided in 2021, and so it's the decision in Champion Breweries and Brauerei Beck that suddenly reached back in time and dragged Limac from his grave, reanimated it, centered it, recentered it, and now both of them are just clashing and trying to decide. We're now taking a second look at Limac. You know, every arbitration practitioner should be happy with the decision in Champion Breweries and Beck and Brauerei Beck. Let me just give you just a synopsis of it, because the two and Limac and Sahelian were it's a case determined on, both cases were determined on a contract that was supposed to be, they were qualifying contracts to be registered under NOTAP, the Nigerian Office of Technology Acquisition and Transfer, whatever. I can't quite remember the NOTAP. Please Google it. I do not pretend to know all of these things, but you know, it's a Nigerian agency and an act that provides for the registration of certain kinds of contracts for technology transfer mostly. And so it's the two contracts, the contract in Limac and Sahelian was implicated for registration. Ditto the contract in Champion Breweries and Brauerei Beck. Limac was a power partnership contract during the unbundling of our national power agency, formerly known as NEPA or PHCN. And so the Nigerian company partnered with a Turkish company for transfer of technology to bid and to operate the Kaduna Disco. Anyway, that contract was qualified for registration under NOTAP. The Nigerian company did not, NOTAP gave 60 days for registration. Nigerian company did not, that is Limac, did not try to register until, Sahelian, sorry, did not try to register until way into 2 years. But then they went ahead, they won the disco, they were operating and they were making money and earning profit. And they were not paying them. They were supposed to pay about $17.5 million over, I think, 5 years to their counterpart, to their Turkish counterpart. They were not paying that money. When the Limac raised the issue, Sahelian said, "Look, you can see that this contract is void because it's not registered under NOTAP." Please note that Sahelian had the obligation to register with NOTAP. Well, they went to arbitration in Switzerland. The arbitral body gave an award. The tribunal gave an award in favor of the Turkey of Limac. They came to Nigeria to enforce, and Sahelian said, "Oh no, it's void." A Nigerian court upheld it for holding that the contract was void because and unenforceable because it was not registered under NOTAP, and that it could actually, more interestingly, and that it could set aside the award. Now, every experienced practitioner knows that under the New York Convention, courts of enforcing courts, only the court of the seat can actually set aside the award. A court of the jurisdiction where you are seeking to enforce can choose not to enforce. They can deny enforceability, but they cannot touch the award itself. But we have the Federal High Court, the Federal Capital Territory High Court Act that purports to empower, well, not purports, actually it's expressly there, empowers the High Court to set aside an international arbitral award where it goes against Nigerian policy, amongst other conditions, public policy. And also this particular case, both cases were decided under the erstwhile Arbitration and Conciliation Act. Anyway, the long and short of it was they went on appeal and the Court of Appeal upheld the decision, holding that it could not be enforced and that the court was right to annul the award itself. It was rested. Limac went to his grave and laid in peace until Champion Breweries decided this year. And the same situation, almost the same fact. The only thing is that the underlying contract was a trademark contract. Anybody who drinks alcohol in Nigeria knows Beck's beer. And Champion Breweries. So they were makers of Beck's beer. And Brauerei Beck is the German company who owns the product itself. And so franchised entered this trademark and franchise agreement with Champion Breweries for the product manufacture of the brand in Nigeria. The same thing happened. They were supposed to register, they did not register. There are other facts anyway, attempts to register, and the fact that NOTAP Act actually rejected the contracts on the grounds, one of which is that if the contract vests jurisdiction over any disputes arising in a foreign country, or the seat of an arbitration is outside of Nigeria, NOTAP will not accept that contract for registration. And the implication of non-registration is that you cannot repatriate your profit. So you see Nigeria, that is otherwise a pro-arbitration country, having a law that manifestly goes against the convention. But that's a topic for another day. Dr. Mohammed was right to say it's not something we can unpack. But the long and short of it was that the same arguments were raised, the same people taking benefits under a contract and then saying, no, it's we cannot perform our obligation because the contract is void. The Court of Appeal, bless their hearts, decided to redeem us all, unshackle us from LIMAC, and held that non-registration does not make the contract void. It will make it unenforceable, but that a situation where you have gone and taken benefits under the contract, it's actually unconscionable for you to come back and say, oh, you cannot, because you did not register, you cannot perform your obligation. And so what ordinarily would have cast us into the dark ages of anti-arbitration disposition, Champion Breweries brought us back into the light of pro-arbitration jurisdiction. So to summarize the question, what it means is that the seat can be everything. Again, the emphasis always is on doing your due diligence. But again, also bear in mind that sometimes, even with the best due diligence and the best choice of seats, you might find that it still will not work. So even these two cases, the seats were all, both of them were in Switzerland, in Geneva, but they came to enforce in Nigeria. One purports to be able to, against our treaty obligations, and the fact that the treaty has been domesticated in Nigeria, purported to be able to set aside the award itself. And so I thought about it, and I felt like maybe they should have gone, if they had the counterparty had assets in France, because French jurisdictions can enforce awards even where the court of the seat has set aside that award. I'm not saying they will always enforce, but I need to, irrespective of the fact that the court of the seat had set it aside. So where the court of the seat is supposed to be the graveyard if you are going to kill the award, Nigeria seems to carve out a portion for itself to say, we too can run a cemetery for that in this place.
Thank you, Leonard Silk. Thank you, Leonard Silk. Thank you so much. This conversation is not one that we can exhaust within the time limit we have, but it's a very interesting conversation, and I think we can even take it offline. So the last question is to Mr. Michael. What final piece of advice for legal professionals who are negotiating an arbitration clause today to ensure that they make the right choices regarding the choice of seat and venue? It's just an advice. And what are your parting final words for us in-house counsel?
Yeah, I think looking at it, thank you so much. And I think it's been very enlightening with what I've heard so far. But I think all of the things we've said must sort of come together as far as everybody's, but the takeaway is that you should look at this from the point of drafting, from that point, and as Henrietta put it, crafting. Because when it comes to the issue of the seat of arbitration, you will find that often the words are couched in simple terms. But as we've seen, it has material and important critical implications for whether you'll be able to do anything else beyond when there's a dispute arises, even in terms of even negotiating settlement, because it has implications even for your bargaining position at the time when you're even possibly considering settling. So from the in-house counsel perspective, it's something that you must bear in mind at the beginning. Of course, you are managing, of all the things you're managing the exposure of the business as far as risk is concerned. So if you must evaluate all the risks that are attendant on the choice of seat. And as we've said, if you don't craft it to take that into account, I mean, you would have obviously a defective arbitration agreement that you can't even enforce. You know, those typical what is normally referred to as a pathological, clause or agreement, because it fails for certainty. It's not clear enough what it is. So it's from the crafting stage, you must be very sure that you have this in mind. Now, one of the other things is that you would, be, to the extent that you have the option between you and the party that you're negotiating with to agree on whether you're doing ad hoc arbitration or institutional arbitration. Given what Godwin said about the institutions, you bear that in mind, because some of them have default positions as far as a seat of arbitration is concerned if the parties don't offer it, if in the event that you don't choose. So that becomes a second layer of a buffer of fallback if in the event that there's an issue wrong with the drafting. Now, the other thing is that, all the other things we talked about, we mentioned interim measures. That is absolutely critical, because with that, if you don't get it right and you choose a seat that impedes your, the arbitration, then, you will not be able to even proceed, even initiate the arbitration, let alone, carry out hearings. Of course, the other consideration, taking of evidence, is one of the things you should take into account, because the framework law is the seat of arbitration law, which will then determine how even evidence is taken, and what rights you have as a party in the course of the proceedings. Then now at the end of it is the issue of the enforcement. What's the value of an award if you cannot enforce it? And if you don't take that in selecting a seat into account, then you would have an empty award that you may not be able to enforce. So I think the critical takeaway for everybody is that you find that some of the laws that are modeled on the UNSTRA model will not use even reference to seat. It will say the place of the arbitration. And that's one of the things that's led to the conflation that the panelists have referred to. So that is something you must bear in mind. So you must take your destiny into your own hands, and then with your counterparty, take that into account. Otherwise, it would have far-reaching consequences for you as an in-house counsel. Thank you so much.
Thank you so much. Thank you, our panelists. This was one very engaging session, and I'll hand over. Thank you so much for all your inputs, all your experiences, because we've learned a lot from your own personal experiences as arbitrators in different parts of the world. Thank you. Coordinator, we've gone 8 minutes past our time, so I'll hand over to you. This session has ended officially. Thank you very much, panelists. Thank you. Mr. Michael, our coordinator.
Okay, thank you to the esteemed speakers for the very insightful responses to the questions. We are now in the question and answer segment. There are quite a number of questions. In fact, the questions are so much that we may not be able to respond to all the questions within the limited time we have. Perhaps subject to what the moderator thinks, I think we should just take the questions in the order that they have been asked.
Okay,
Madam
so
Moderator, I don't know if that's fine by you.
I think that's fair. First to get responses, but I'm unable to see all the questions from this system. Where is
okay,
this? Where
what I did was, while the questions were coming in, I was noting the questions.
Okay. So let's have them from you, Mr. Michael.
Okay, so the first question is where an arbitral clause stipulates that the governing law for any arising dispute shall be Nigerian law without any express stipulation as to the seat or venue. Does this give rise for a presumption that the seat of arbitration is Nigeria?
Ms. Henrietta, please.
I'll take it
Can you
again.
answer
Where
this question
an arbitral clause,
because you touched on this issue?
okay.
Hi, I think there is some disturbances and it was not quite audible to me. And even the screen at the moment for me is blank. I will answer the question. Could you just repeat, please?
Okay, I'll take the question again. Where an arbitral clause stipulates that the governing law for any arising dispute shall be the Nigerian law without any express stipulation as to the seat or venue, does this give rise for a presumption that the seat of arbitration is Nigeria?
Yeah, in between there were disturbances. So what I've understood so far is the question is that where there is a mention of Nigerian law in the contract, right? Am I right?
Yes.
Because there has
But
been
there's no
disturbance.
express stipulation as to the seat or venue.
Okay, so there is no mention of venue, but there is mention of Nigerian law, right?
Yeah, so the question is, can you hear
There's
me?
no venue. There's no
Henrietta, can
mention
you
of
hear me?
seat.
Yes, we can.
Yeah, so the question, Henrietta, is
Yes.
the contract itself says that the arbitration will be subject to Nigerian law, but it does
Yes.
not mention the seat or the venue. So the
Awesome.
question is there a presumption that the seat would be Nigeria?
Yes, of course. The seat would be Nigeria, obviously, because they said that Nigerian law is applicable, right? So this is the answer, plain, simple, and clear. That so with this, suppose just assuming, not presuming, assuming that this itself is the draft clause. The question itself is a draft clause. Assuming that the question itself is a draft clause, that Nigerian law will apply. There is no mention of the word seat, but there is mention of the venue. So law that is applicable would be presumed to be the seat. So that means Nigerian law will be applicable. Venue can be anywhere. Venue is the venue points out towards the practicality of the proceedings, the physicality of the proceeding, but the home, the legal home would be the seat. And where seat is not mentioned, that means the law, that is a Nigerian law. That's the legal home.
Thank
Can
you.
I quickly, moderator, can I quickly?
Yes, please. Yes, please. Go ahead.
Thank you, Henrietta. This is a segue to from Henrietta's answer. So, and I absolutely agree with her. If there's no legal framework addressing that issue, I would like to refer Nigerians here to Section 16, 1 to 5 of the Arbitration and Mediation Act, which seems, again, I did mention it, that it seems to have addressed situations falling within the same ballpark. So Nigerian law is set to apply, but no seat, no venue is mentioned. It would appear that the Arbitration and Mediation Act in that scenario would vest the arbitral tribunal with the jurisdiction to decide where the seat would be. Now, I'm going to go out on a limb and suggest that if they were to make that such a decision, obviously they will come back to the point that Henrietta has made, especially if you look at it and looking at the number of the parties and the proximity to the question of cost and logistics and everything. I'm sure that ultimately the decision maybe not, I'm sure maybe an overspeaking, but ultimately it is very likely that that decision will be made that Nigeria, anywhere in Nigeria, will be the seat of the arbitration. But generally, in the absence of that, it maybe direct answer to that would be that you go from that absence, that omission, straight to the jurisdiction of the tribunal to determine what that would be. Section 16 of the AMA.
Thank you so much. Thank you. Coordinator, I think, okay, we may just be able to take one or two more questions because we have just about 14 minutes, 16 minutes to the end of the session. So maybe 1 or 2 short questions before I hand over to you for the closing.
Okay, there's another question here expressly directed to Henrietta, which is, can the law of the seat be different from the governing law? If yes, are there any downsides to adopting this approach?
Interesting
Henrietta,
question.
I don't know if you got the question.
Yes, I got the question. Interesting question. Whether governing law can be interchangeably used as seat. Right?
No, whether the law of the seat can be different from the governing law.
Whether the law of the seat can be different from governing law. So when we're talking about the seat, we are talking about the contractual clause here, whether we are mentioning the seat here. So in my understanding, in my experience this far, we do not use the word interchangeably, but of course we say that, see, like the case that I mentioned earlier, Arif Azam versus Micromax 2024, the Supreme Court of India, what it did was the only word that was mentioned in the case in the draft was venue. The arbitration clause was venue. So what they did was they went to see some more points in the contract, and they found that the governing law is mentioned. So the governing law that was mentioned was Dubai laws. So that means they concluded that the seat would be Dubai. Are you understanding? So sometimes I wouldn't say that we can use it interchangeably, but it can presume to be as governing law can be presumed to be as seat.
Okay, thank you.
I hope I've answered the question.
Yes, certainly, and in a very short time too. Thank you very much. Next question.
I would just like to add one more thing.
Okay.
Probably this would shed some light. The thing is, the procedural law is, or I would say, seat is reflective of the procedural law, right?
Yes.
So the application of the procedural law would not change, whereas the venue can change as per the choice of the party. So that means the seat is directly reflective of the governing law. So that cannot be changed easily. Whatever is mentioned in the contract, in the arbitration clause, that is applicable. Why? Because the parties have agreed to that particular procedure, to that particular governing law.
Thank you, Ms. Henrietta. Yes, I believe that this question has been answered satisfactorily. We have only 3 more minutes for one more question, coordinator.
Okay, so there's a question here that says, I need more clarification on the seat and venue of arbitration.
I think this has been answered.
Yes.
Has
then
been
another
answered.
question is, who determines or chooses the seat of arbitration between parties in a dispute?
Both parties agree. Both parties have to agree. Yes. What's the next question?
And then what happens where the parties are not agreed on seats?
So, can I throw that?
I think had touched on that.
Yes, it has been. So let that be our last question. If more light can be shed on that question, either Leonard Silk or Mr. Michael from Ghana, anyone can answer this question for us, please, so that we have 2 minutes.
There's also an important question here that I think we should consider. Won't conflict of law affect seats and arbitration?
I think in respect of the earlier question, from the Ghana perspective, the law is quite clear. The Alternative Dispute Resolution Act is quite clear, in line with party autonomy and the fact that the parties themselves can decide. They are required to decide. But where they don't, the law is quite clear that the arbitral tribunal can. And some of the tribunals in some of the cases have applied a 3-test thing where, first of all, it must be express, if not, then implied. And if it's implied by their conduct that you can, attribute a seat to the parties, that's what the law applied. And the last one will be where there's a actual close connection in terms of the taking all the circumstances into account. The law talks about the fact that decision regarding that must take into account all of the circumstances, and that's what happened in the Waterville case that I cited earlier, where they applied a 3-test approach to then arrive at what the seat was, once even when it wasn't expressly determined, in the agreement.
Okay, thank you very much. Coordinator, now we are in the session, the closing part of this session.
Yes.
We are done with the question and answer. Thank you. Okay.
Sorry,
yes.
My apologies, please, because obviously this is a learning. It's just been brought to my notice, and I thank Dr. Mayomi for drawing my attention to it, that the case of oil and services, let me see.
South Africa.
Oil and Industrial Services Limited and Hempel has actually was the first to deal with LIMAC, the damage done by LIMAC, by establishing expressly that only the court of the seat can set aside. It doesn't solve the problem though, because we still have statutes existing in our corpus juris that purport to expressly vest local courts with jurisdiction to do that. So there'll still be a legislative intervention for that. But I thought I should just put it out there. And again, I'm grateful to Dr. Mayomi. Thank you. And grateful to you too for allowing the gate crashing. My apologies.
Thank you. It's okay. This is a learning process. The time is not enough, but we have to manage with the time that we have. Thank you for all your inputs. We really appreciate your time. We really appreciate your contribution. So I'm going to hand over to our coordinator and go through the closing process of this session. Thank you very much.
Thank you very much, Madam Moderator. At this point, I'll call on Professor Paul Idondiye, the first Vice Chair of the Institute, to give us some conclusion highlights regarding this webinar.
And for those who don't know, an institution on every topic arbitration.
Oh, yes.
Thank you very much. I've thoroughly enjoyed myself. Good afternoon, everybody. On behalf of our chair, Mrs. Shola Adebomire, the members of the ESCO and the branch, I'm particularly honored to end this webinar. I'm honored in many respects because I was once a general counsel. So I know that this webinar is essentially for general counsel, in-house counsel, or corporate counsel, because they're the ones that draft and negotiate, if I may borrow the word of Arietta, craft arbitration clauses. I'm a disciple of the school of the doctrine of covering the field, the doctrine of covering the field. I think that Godson, Arietta, and Michael have comprehensively covered the field, and we must thank them for so brilliantly discussing a topic that is often ignored, but a key to the success of arbitral proceedings. I often ask this question: do we have a problem between seat and venue, because it's often referred to as a midnight clause? Maybe you should start drafting it early in the day instead of either in the midnight or in the early hours of the day. Some also see it as a minor term. I tell you, it's not a minor term, it's a major term of the contract. Having said that the speakers have comprehensively covered the field, I would like to draw attention to the P&ID arbitration. P&ID arbitration, where in terms of seat, what the agreement provides for is seat of arbitration. Saying seat of arbitration, London. Seat of arbitration, sorry, venue for arbitration. venue for arbitration, London. And English courts took that to mean that the seat is London. There were very many issues with that arbitration, but I think that we, as corporate or in-house counsel, we should try and avoid drafting pathological clauses. We stop drafting pathological clauses. Like the moderator said, there are standard clauses. All decisional rules provide for standard clauses. Why do we leave them and try to craft our own clause that creates problem? So we should try and adapt standard clauses. Even in looking at UNCITRAL, if you look at Article 20 of this UNCITRAL model law, you find that it uses place to refer to seat, place to refer to venue. If you even look at the LCIA, it's the same confusion. So I don't think that these model laws and rules are helpful in all cases. But we must sit down, learning from our experience and from events like this to tell ourselves, because like I said, as general counsel, as in-house counsel, as corporate counsel, we are the ones that negotiate and draft these clauses. We should avoid pathological clauses. I've been warned not to talk too much, so I'll stop here, but I've thoroughly enjoyed myself. I hope all of you did. Again, hello?
We can hear you.
Okay.
Can hear you.
The pool came and I thought I was shut out. I'm so proud to be a member of CIAB, and I think that what Shola will be doing is to have seminars in very topical areas. Seat and venue, are they used interchangeably? Some will use seat, some will say place, some will say venue, some will say location, some will say forum, some will say locale. Are they used interchangeably? Not because I chair the committee that drafted the Arbitration Act of Nigeria, but if you look at the way we drafted Section 32, we were very specific on the difference between seat of arbitration and venue for hearing. So I think when we are drafting, we should emphasize seat of arbitration and venue for hearing, not venue for arbitration. It creates a problem. So seat of arbitration is the home, the legal home of the arbitration. The venue for hearing can be anywhere. Once again, I thank all of you for attending, and I hope that although it's a very confusing area, because like I said, the words are used strategically. UNCITRAL will not be too helpful. The English Act will not be too helpful. The English Act use seat, UNCITRAL use place. And so you ask yourself, what is the difference between seat and place? Is it place of hearing or place where that has the governing law of the contract? But once again, I thank all of you, and watch out for more of this kind of refreshing courses from the Chartered Institute of Arbitrators, Nigeria branch. Thank you very much, and have a good afternoon.
Thank you very much, sir. I also like to call on Mrs. Shola Adegbomire to also give us her closing remarks. I can see she's on the call.
Thank you very much. I want to really thank the Corporate Counsel Committee for putting this webinar together. They've been doing a lot of great work, and the CIAB we really appreciate. To our able moderators, to our speakers, you have really enlightened us. You have built capacity for us. And the whole idea of these webinars is to build capacity, that we keep learning more and more about the principles of arbitration, the process of arbitration, that when we are called upon to sit as arbitrators, we actually can distinguish things correctly. So now I don't think anybody on this webinar will have a problem distinguishing between the seat and the venue of the arbitration. A problem that many people could not distinguish. What law do I use? Do I use the law of the seat or do I use the law of the venue? What does the AMA say? What does UNCITRAL say in international arbitrations? And these are the things that we have learned today. And I want to thank our speakers so very much. And I want to thank our moderator so very much. And I want to hope that when we call upon you again, that you will come and you will speak to us. Prof too has added a lot. Prof is a professor. So you cannot, professors teach. So even for 2 minutes, you teach us something, and we really appreciate. To the committee, the in-house council committee, I always say it, and I'm saying it again, you guys are doing a great job. We're learning so much. We're becoming much better arbitrators, each and every one of us. And for those who are not yet our members and are attending this program today, this webinar today, please feel free. I think the Institute will put how to join, how to become a member of the Institute. There's so much happening. Please, we invite you to join. You can either start as an associate to do a one-day course, and then you can move on to become a member of the Institute. As an associate, you have the letters ACIAB after your name. As a member, you have the letters MCIAB after your name. And you can move from that to become a fellow with the letters FCIAB after your name and become a chartered arbitrator. And the Institute, because it's an international body, you get the opportunity to network with members from all over the world. We always have lots of conferences, meetings, all kinds of things going on in our backyard here. Our conference this year is in Lagos. We have things going on in Ghana, in Kenya. There's a conference in Egypt, Cairo, Egypt, this next month, October. Join us and let's all do this work of, sorry, Prof. Let's all do this work of dispute resolution, conflict management. Let us all do it together because there's so much work to be done in that space. So once again, and to the chair of the in-house committee, Dr. Esson, and all the members, I could start naming them one by one, but I know I have just maybe a minute left. And just looking at, I'm sure the moderator is saying, thank you, thank you, thank you. So thank you very much. We look forward to speaking. I hope I'm not muted. We look forward to hearing from you again. I think my video has been, thank you. My video was closed. We look forward to hearing from you again. And for all the people on the back end, our able honorable secretary, Reverend Dr. Agbelusi, our GM, Chinelo Agbala, and all those in the office making this happen. I also want to say thank you to everybody. So once again, thank you everybody, and you all have a wonderful rest of the day. Thank you.
Thank you.
So thank you all. We've come to the end of the webinar. Please ensure you fill the Google form that has been shared so that you can get access to your, so that you can be awarded your CPD points for those in Nigeria. Thank you very much.
Bye-bye, everyone. Thank you.
Bye.
Bye, everyone. Thank you.
Bye.
Bye.